In 2016, a judge wrote a cost decision for a custody case. What he said became one of the most quoted passages in family law.
These are nice, average people, of modest means, now considerably more modest. They drive old cars and probably pinch pennies shopping at Costco. And yet somehow, between them, they spent more than $500,000 on lawyers to have a judge tell us something we could arrange ourselves.
More than $500,000 for one child. This is how it happened, and why the judge needed 822 paragraphs to explain it. Davis Jackson and Eileen Mayerle met in 1993 at a company outside Hamilton, Ontario. They dated, moved in together, bought a house in Waterdown, and married in 2004. Davis was a police officer, Toronto Police Emergency Task Force. Income at trial, about $100,000 a year. Eileen worked part-time from home, around $30,000. There were fertility struggles, a miscarriage, and on June 16, 2007, their daughter Paige was born. The pregnancy was shadowed by loss. Both their dogs died prematurely while Eileen was pregnant. Davis testified she went into a depression. Justice Pazaratz accepted Eileen's account. They grieved together, and there was no lasting impact on her parenting. They separated July 26, 2011. For the first year, the court found Eileen was making good, child-focused decisions. Then came August 2012. Davis had started dating a colleague. He took Paige to his girlfriend's cottage after promising she wouldn't be there. He lied, then admitted he'd moved in with her. That same month, Davis sent Eileen an email. It became so significant that Justice Pazaratz used it as the opening epigraph of his cost decision.
We are both reasonable people, and I really think we can work this out without spending $40,000 to $50,000 apiece in lawyer fees, only to have a judge tell us something we could arrange ourselves. Please, I'm begging you to be reasonable.
He predicted the disaster. What followed proved him right, and it was the child who paid. What Paige lived through over the next 3 years was documented by 20 witnesses, multiple Children's Aid Society investigations, and a professional custody assessment. Christmas 2012. A voicemail was placed for Davis, not by Paige on her own, but with someone dialing the phone for her and watching as she spoke.
Daddy, I just don't want to go on Christmas Eve. I want to stay home because I'm going to see you for a long time and I want to be home. And I don't want, and because I miss you for a long time and some other time. And so, a different day. And you're not going to be there because you're going to be at work, night shift. So you're not going to be there. Bye, Daddy. Oh, wait, and bye.
The recording was played in court multiple times. By the following year, Paige's school was on high alert. On transition days, the days she moved between parents, Eileen would whisper something at drop-off. Paige would start crying. December 2013, the Grade 1 Christmas celebration. Davis came to collect Paige. Eileen bent down and whispered in her ear. Paige began to cry. Eileen became emotional, refusing to let go, reaching for her again and again. The school contacted the Children's Aid Society. Earlier that day, Paige had a breakdown in her classroom. She was banging her fist against her thighs, saying, "I'm sorry," over and over. Then she said this to her teacher.
Madam, I trust you. I like school. I like you as my teacher. But Mummy tells me that you're a bad teacher, and I shouldn't trust you.
She was 6 years old. Custody assessor Michelle Hayes was appointed under Section 30 of the Children's Law Reform Act. And Paige kept talking to workers, teachers, counselors. She said her mother called her father a loser and a jerk. She didn't like discussing him with her mother because her mother might say things like, "Your dad doesn't care about you." That made her feel sad. In August 2014, a CAS worker conducted the 3 houses exercise with Paige. Draw your good things, your worries, your wishes. Under wishes, Paige drew this:
wishing her mother would not say bad things about her father. Her mother says, "Dad's a loser and a jerk." Her mother tells her not to tell anyone.
The physical toll was documented. On transition days, Paige suffered headaches, dry heaves, vomiting. She worried about saying something wrong at the other parent's house. Birthday parties became competitive. Homework disappeared on transition days. Her legal surname, Jackson, was replaced with Mayerle on school records. Through all of it, Paige had one persistent request, one she raised so often that custody assessor Hayes specifically noted it.
Paige said she did not understand why her parents could not just go to the parking lot and just say sorry. Hayes said Paige made this common-sense suggestion several times.
But the recordings changed everything. Justice Pazaratz found that Eileen had been systematically audio recording Paige after every visit with her father, building what the court described as a database. The recordings were never disclosed to the other side. They surfaced only when Eileen's lawyer tried to use one during cross-examination. The court found the pattern was clear: prolonged, dramatic goodbyes before visits, then conspicuous recorded debriefings immediately afterward. Justice Pazaratz wrote that the message being conveyed was that contact with her father was something to worry about, that only her mother would protect her. Then came the instruction Paige said she received about haircuts.
But Paige told him that after the 2014 haircut, the respondent told her that if Daddy tries to cut your hair, drop to the floor and do your "Stop, Stranger, Police" cry. The applicant explained, "Stop, Stranger, Police" was a street-proofing technique whereby children are warned that if anyone tries to do anything bad to them, they should fall to the ground, kick their feet, shout for attention, and create a commotion.
Her father, a police officer. The court found he was being treated, through his own daughter, as a danger to run from. The school principal eventually issued a formal warning to Eileen, threatening a trespass order. The court found Eileen had made consistent and deliberate efforts to marginalize Davis from Paige's education, withholding homework, tampering with school documents, removing Paige's school agenda on transition days. Justice Pazaratz documented stalking. Eileen driving behind Davis's car after he collected Paige for access. Surreptitious recordings of teachers and CAS workers, never disclosed to the court until they were inadvertently revealed. Custody assessor Hayes had filed a 63-page report. She found Davis an excellent witness and recommended sole custody to him. Justice Pazaratz accepted her evidence entirely. 20 witnesses were called. Every single one, except Eileen, testified that Paige was equally bonded with both parents.
All 20 witnesses used the same sorts of adjectives to describe Paige: delightful, caring, loving, kind, considerate, sympathetic, bright, witty, fun, pleasant, sensitive, sweet, adorable, outgoing, popular, usually happy, but sometimes very sad.
The court's language about what had been happening since September 2012 was unambiguous.
The respondent embarked on a campaign to eradicate the applicant from Paige's life in every possible way.
Justice Pazaratz summarized the mother's parenting conduct in 5 words, placed in a single, unambiguous sentence.
The respondent was overt, manipulative, scheming, deceitful, and oblivious to the needless family suffering she perpetuated for at least the last 3 years.
And then came the judge's verdict on what all of this actually was. After 36 days of trial and 20 witnesses, Justice Pazaratz turned to his findings. The governing standard in Ontario is the best interest of the child. The court assesses bonds, stability, each parent's ability to support the child's relationship with the other. His language was unlike anything typically seen in Canadian family law.
What happened in September 2012 and October and the months and years that followed was nothing less than emotional child abuse.
The court identified the root cause, what Justice Pazaratz called a perfect storm of three destructive emotional forces.
September 2012, the respondent appears to have succumbed to a perfect storm of unbridled, destructive emotions. Intense anger and resentment toward a former partner. An obsessive, smothering possessiveness toward their young child. Paranoia and panic.
And then Justice Pazaratz wrote what may be the most chilling line in the entire judgment.
The most frightening aspect of the respondent's evidence: she still doesn't think she's done anything wrong.
The cost decision, released 2 months later, found something further.
I agree with the applicant that there are instances of bad faith behavior by the respondent, notably manipulating and falsifying evidence.
The ruling came January 5, 2016. Justice Pazaratz granted Davis sole custody of Paige Emily Jackson, with sole and final decision-making authority over every aspect of her life. The mother retained access, on a week-about schedule, but with a direct warning about what happened next.
If she doesn't stop the mind games and manipulation, her access to Paige is going to be continually cut back until she gets control of herself.
But what about the money? The cost decision came March 3, 2016. Davis had spent almost $300,000 in legal fees. Eileen had spent more than $200,000. Combined, more than $500,000 by two people of modest means who drove old cars and shopped at Costco. Davis asked for $250,000 back. Justice Pazaratz awarded $192,000, less than requested, noting that even winning big does not entitle a party to a blank check. Now, remember that email? August 8, 2012. Davis had predicted they might each spend $40,000 to $50,000 on lawyers.
In retrospect, his somber warning about spending $40,000 to $50,000 apiece in lawyer fees now amounts to wishful thinking.
On finances, the court imputed Eileen's income at $60,000, finding she was deliberately underemployed. Child support was set at $324 a month. Spousal support, $700 a month for a maximum of 5 years. The house in Waterdown would be listed for sale. And what all that money represented.
No matter what costs order I make, the financial ruin cannot be undone. They'll never recover. Their 8-year-old daughter's future has been squandered.
At the end of 822 paragraphs, Justice Pazaratz wrote one final instruction to both parents, built around the words of the 8-year-old at the center of it all.
Both parties need to reassure Paige that they've gone to that park and said sorry to one another, and that she can go back to being a carefree little girl who loves everyone.
Davis and Eileen were not monsters. Justice Pazaratz said so himself. Nice, average people. They drove old cars, they loved their daughter, and they incinerated her financial future because neither one could stop. That's the lesson at the center of this case. Courtrooms are full of people like this. Not criminals, just ordinary people who let anger become litigation until the only winner was the billing cycle. If this case moved you, subscribe to The Legal Brief. Leave a comment below. These are real decisions from real courts about real people. They deserve to be heard. I'll see you in the next one.